All right, this is in the matter of the people of the state of Michigan versus Miguel Mansour, file number 25-22176FH. Mr. Mansour, Ms. Underwood, you are going to help represent him on sentencing. Is that correct, Ms. Underwood?
I don't represent Mr. Mansour, I don't think, Your Honor.
Okay, never mind. All right. You said hello, so I thought maybe I appointed you for sentencing. All right, Mr. Mansour, you do not have an attorney at this time, is that correct?
I don't need one. I requested not to have one.
Okay, did you get a copy of the pre-sentence report?
Not yet.
Okay, Miss Holly. So you're gonna have to, he didn't receive a copy. Did you send him a copy?
So we don't usually do the attorney. Your staff might have had to do it.
He doesn't have an attorney.
No, so I don't know.
Usually, usually.
Get to him, like.
Well, okay. So Mr. Mansour, usually like they review it with them, Chris Jones.
We never had a waiver, right?
Yeah, so Mr. Mansour, would you like an attorney for sentencing? We got to get you a copy of the PSI. So obviously we're not going to be able to sentence you today. And would you like an attorney just for sentencing to review the PSI with you?
No, I'm in here for life without parole. I don't need an attorney. You're adding time on, infinite time. So I choose to just plead guilty to whatever you guys want to charge me with.
You already pled guilty, but I have to make sure you have a copy of the PSI to review. So I'm gonna get a copy of that sent to, what facility are you at?
Where am I at?
Say it again.
I didn't hear you. I didn't hear you.
Okay, where are you currently incarcerated?
Marquette Branch Prison.
Okay, so Miss Adams, we can email that to a social worker there or somebody, is that correct? Or do we mail it to them, or?
I thought probation sent to the prison, but I'll just send him a copy.
All right, so Mr. Mansour, I'm gonna adjourn your sentencing 2 weeks. And we are gonna mail a copy to you and then also provide a copy to the social worker or somebody that you work with at the prison. So that way you have an opportunity to read this before we sentence you, okay?
Okay, I'll do that.
Okay, Miss Adams, what day should I adjourn this to? I know. One thing, I saw that.
That would be Thursday, May 29th.
All right, so I'm gonna set this over to May 29 at 8:15 in the morning. And Mr. Mansour, we will make sure to get a copy out to you, okay?
Thank you.
All right, thank you. Have a good day.
You too.
Thank you. So Ms. Underwood, I'm gonna have to shut down. You're all set, Mr. Mansour.
I know, I'm calling him. What's up?
Say it again.
We're done. She said we're set.
Oh. Okay, so Ms. Underwood, give me a minute. I gotta shut down. Becky, the computer or the Polycom is not working.
I'm here on Lake, Your Honor.
Okay, okay. Hold on. I have two. All right, Lake. Miss Walsh, we're gonna take Lake. All right, this, Miss Lake, can you hear me?
Yes, I can.
All right, this is in the matter of the people of the state of Michigan versus Kaylee Dawn Lake, file number 25-22146FH. So Miss Lake, I have a pre-sentence report from Miss Walsh that states that she was unable to communicate with you to prepare a pre-sentence report. Do you understand that?
Yes, ma'am.
Okay, so I'm encouraged the fact that you did call in today. So Miss Walsh, I recognize she's in Tennessee, so how do we proceed at this point?
Well, I'm not sure. I've tried to reach out. Emails is not gonna work for the length, for the, as big as our packets are, so I don't really know.
How many pages is the packet?
32.
All right, so Miss Lake. Miss Walsh we're gonna have to mail the packet, but Miss Lake, listen, you have to take care of this. If you don't, I'm gonna require you to come back to Michigan. And then if you don't come back to Michigan, I'm gonna issue a warrant for you. And then at some point, you're gonna get picked up and then they're gonna transport you back. So this has to be a priority for you, okay?
Yes, ma'am.
All
I'm
right,
sorry.
so are you employed?
Yes, ma'am.
Okay, so we're gonna mail you this packet and you're
Okay.
gonna sit down and you're gonna fill it out and then you are gonna mail it back to her, okay?
Yes, ma'am.
And I don't know how much that's gonna cost, but you're gonna have to take care of that. And
Yes,
then, Miss Adams, what is the sentencing date in June we're using?
Judge,
We'll need at
June
least-
27th at 8:15.
So I'm gonna set this out to June 27 at 8:15 in the morning. If
Your Honor,
the
could I
packet is
have-
not,
I'm sorry. I didn't mean to interrupt.
Miss Lake, if we don't receive it back on that day, I will issue a warrant. Do you understand?
Yes, ma'am.
All right, Miss Underwood, what were you gonna say?
Could I have a brief breakout with Ms. Lake?
Yep, and Miss Lake, Miss Walsh is gonna need a valid phone number because she will also need to speak with you. Do you understand that?
Yes, ma'am.
Why are you raising your hands, Miss Underwood? What are you asking?
Because that's what was going to get from Ms. Lake and
All right, excellent.
I have
because
If
I've
you
been
can
trying
get-
to reach her.
What, Miss Walsh?
I have a phone number. The problem is it only works with Wi-Fi, so she hasn't. It is what it is. I can't get a hold of her when I need to.
All right, so Miss Underwood, I'll open up a breakout room and please verify your address and a phone number, all right?
Yes, ma'am.
Thank you, Your Honor. Sorry.
For Miss Walsh. All right, Miss Lake, I'm gonna open up that breakout room to talk to Miss Underwood. Not have Mr. Mawad yet, but I'm sorry. Is Amber Straub here?
She's in jail.
Is she here in jail or at the jail?
She's at the jail.
Oh.
I'm chilling through.
Hi, this is Judge Anzalone. I am ready for Amber Straub, and then I am ready for Tony Rowe. And that's it for now.
Okay, sounds good.
All right, thank you.
Yep, no problem.
Bye.
Bye.
I lost. Did you already talk to Miss Underwood, Miss Lake?
Yeah, she just told me to give her office a call to get that updated phone number and everything.
All right, Miss Walsh, do you want to break out room with her real quick to verify her address and phone number again?
Has it changed?
My address, do you have my address in Tennessee?
Okay,
Your
I'm
phone
gonna
number.
put you to
Phone number changed.
hold on, I'm live, so I don't want to, so I'm gonna put you two in a breakout room, and when you're done, Miss Lake, you're free to go.
Okay.
All right, Mr. Steins, can you hear me?
Yes, I can hear you. Can you hear me?
Yes, I can. This is in the matter of the people of the state of Michigan versus David Royal Steins, file number 24-22047FH. I have Carly Zilke appearing on behalf of Mr. Steins. This is the date and time set for sentencing in this matter. Ms. Zilke, you've had an opportunity to review the pre-sentence report with Mr. Science.
Yes, Your Honor.
All right, so Mr. Sines, you've had an opportunity to read and review the pre-sentence report.
Yeah.
All right, speak up a little bit, and you've had an opportunity to discuss that with your attorney.
Yes, I had an opportunity to discuss that with my attorney. Your Honor.
Okay, and you are satisfied with her as your attorney and the advice that she has given you?
Yes, Your Honor.
All right, Ms. Silky, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No.
Probation Department in this matter has calculated the minimum sentencing guidelines to be 5 to 23 months. Do you agree with that computational guidelines?
Yes.
Before the court passes sentence, is there anything you'd like to say on behalf of your client, especially regarding the treatment program he was in Salvation Army Harbor Light?
Yes, briefly, Your Honor. Mr. Sines has been doing very well. He has been, he was released from Lenawee County Jail. He was there for about 24 days, I believe, and was released directly into Harbor Light. That was just shy of 6 months ago. He is doing very well. He's graduated from the residential program there. There is a progress report that I believe was included, dated 5/5 of 25. With all negative test results, all good as far as attendance, punctuality, attitude towards treatment, and confirmation that they are recommending he continue with the present plan. He is excited about sobriety, very pleased, as am I, that he is doing so well, and is intending to go into sober living as a next step and continue with his intensive outpatient treatment. So in general, things are going really well for him. He's doing well with the program that he's in, and that's the context we'd like the court to know.
Okay, all right, Mr. Sines, is there anything you'd like to say on your own behalf?
Yes. So basically I'm going to IOP and I'm working on going to sober living after this. So that's about all I have to say.
Okay. All right, well, I do appreciate all the hard work you've done to complete the program and continue in it. So that's something you should be very proud of. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principal proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and protection of society. Sentence of the court that you'll be placed on probation. Let's see here. There's no recovery court on this one, right? No, I didn't think so. For a period of 2 years, during that term of probation, you're not to use or possess any alcohol, use any illegal controlled substances, use prescription drugs only as prescribed, complete a substance abuse assessment when referred. I'm assuming you've already had one done.
Yes.
Complete all mental health, domestic violence, counseling, or other treatment as recommended by your service provider, not to use any item as a weapon. You must submit to search of your person and property, including but not limited to your vehicle, your residence, your computer, without need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. I will give you credit for 24 days already served at the Lenawee County Jail. There's a $130 crime victim assessment fee, $30 per month supervision fee, $60 if we have to put a tether on you, $750 in court costs, and $68 in state costs. So are you living in Monroe County now?
Yes, I was gonna actually ask you because I'm staying over here. I will be like leaving like ILP. I think it ends in like I'm on a block grant right now, like due to like the funding, here, so I think I'll end up leaving in the middle of June in about a month. So, I'm thinking about, is there any way I could get my probation switched to Monroe, or does it have to be Lenawee?
So we do transfer probation to where you live.
Okay.
So if you are living in Monroe County, they can process the transfer, right, Ms. Holly?
I need an address and he's gonna somehow need to get out here to sign the probation order.
Yeah, so Mr. Sines, you'll have to have a permanent address in Monroe. And at some point though, you're gonna need to come here to sign your probation terms. Are you allowed to leave for the day?
Am I allowed to leave for the day? I don't know. I got class as soon as I get out of here.
So you're still at Harbor Light, right?
Yes, I'm still at Harbor Light.
So he's,
I don't think he's in the, I don't know where he's at right now. He's not in the residential, so I don't know where he's at right now.
so you're not in the residential one, you're in a different
yes, I'm
part of the
still-
program.
I'm still in residential. I'm living here still in residential, going to intensive outpatient therapy right now. It's 3 times a week. And I stay here and then I'm leaving. I think it's like in June, I think I'm leaving, like beginning of June, a couple weeks to maybe not even a month, middle of June or beginning of June's about when I get out of here.
Okay, so you're gonna need to work on, once you're out of that program, getting here to sign your probation terms. Because
Okay, I
that's
can do that, yeah.
required. Yeah, you're
That-
gonna need to
I
come down
understand
to, okay, you need to come and meet with Miss Holly. Do you have a phone number for him?
Yeah, that's what I was gonna ask. I need a
Can-
phone number at least.
Well, I'm on YouTube, so I can't get a phone.
I should have a good phone number.
You have a good phone number? Can you get that to Miss Holly? All right, so Mr. Sines, once Miss Holly's gonna get a hold of you, and obviously if you're not able to leave the program right now, when you are able to leave, you're gonna need to come down and meet with Miss Holly and sign it.
That's fine.
You're also
That's
going to
fine.
have to obey and comply with any other provisions in your articles of probation. And as I said, you have to come in person to transfer to Monroe anyway at some
Okay.
point. So, all right, so Mr. Sines, Miss.
I can arrange that to I can arrange to get a ride out there, before I get out of here.
Perfect. Perfect. All right, so do you have an address for him?
Yes.
All right, could you get that to Miss Adams?
Yes.
All right, so Mr. Sines, we are from the court going to mail to you an envelope. And in that envelope will be 3 copies of your notice of right to appellate review and a self-addressed stamped envelope. I need you to initial and date 1 copy where it's marked, fold it up, put it in the self-addressed stamped envelope and drop it off wherever outgoing mail is. So
Okay.
that's acknowledging you received your advice or your notice of right to appellate review. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Okay, yes, Your Honor.
Anything else?
No, Your
All
Honor.
right,
No,
Mr.
Your Honor.
Sines, you are all set. Thank you so much and good luck to you.
All right, thank you.
Thank you.
Thank you. All right, okay.
Interesting too.
Did you guys coordinate that outfit, Miss Holly and Miss Silky?
I know, I know.
Mr. Rowe. So Mr. Murphy, are you on both of Mr. Rowe's files or is Michael Dagger Margosian? Oh, no, these are Michael Dagger Margosian. He's your attorney, right, Mr. Rowe?
Yes, ma'am.
All right, so we need him. So he's next door. So hold on a second. Mr. Mawad, good morning.
Hi, Judge. Did I boo-boo?
Did you boo-boo?
Yeah.
I don't
You were calling me on the Wayne Scott matter? The 3, is that what you guys wanted me on for, or no? Doug
yes.
Hartung text. Okay, I thought we adjourned it, Judge. I'm sorry, because they're both going into, but that's okay. Whatever you want me to do, or I'll do.
We have Mo, we have Wayne Scott. I think those are the two we have with you, but we still had, we left the show cause on for today.
And the female is on with him.
Oh,
Caitlin Maynard.
Oh, and Caitlin Maynard as well. Who's the
It's
yeah,
Doug.
so we
It's
left
Doug.
the show cause on.
Okay, I did not know there was a show cause, and I have to apologize to everybody because I talked to Wayne Scott and Maynard yesterday. They are both supposed to call Mr. Koss this morning and let him know that they're going into a rehab on Saturday near Battle Creek Bear something. So I thought the matter was adjourned. I did not know about the show cause. I can try to get him on. In all honesty, I'll try to get him on. We can do most sentencing today if you want to get that done and over with. He's been in such for a long time. Whatever you want me to do, Judge, I'll do it.
Well, if you're ready to do Mo, we can do Mo.
We can do that.
All right, give me just a moment and, all right, I have Tony Rowe and, Strom. Jim. Diane, I have Amber Strom. Diane Molitano on behalf of Amber Strom. Hold on, let me call the case first. This is in the matter of the people of the state of Michigan versus Amber Rose Straub, file number 25-22181FH. I have Diane Moliterno appearing on behalf of Ms. Straub. Ms. Straub is joining us from the Lenawee County Jail. Ms. Moliterno, you did receive a copy of the pre-sentence report. You had an opportunity to review it with your client.
Yes and no, Your Honor, and I do apologize. There was an error on my schedule through my database as to this hearing, so I would like just a short adjournment so that I do have the opportunity to go see her and go over this with her.
Okay. Ms. Straub, did you receive a copy of the pre-sentence report?
PSI?
Yeah.
Yeah, like 40 days ago.
All right, hold on one second. Ms. Walsh, there's not a recommendation for further jail, correct? Or is there?
She's in jail anyway.
On something else?
Yeah.
Okay. You're in jail on something else, Ms. Straub?
There is, Judge, she was just approved yesterday for recovery court, so that's why it wasn't in the initial PSI, but it would.
Ms. Straub, what did you say?
I just want to max out.
Oh,
Okay. Ms. Adams, I need another date for sentencing on this, at least 1 week, but our next available.
We have 8 scheduled next Thursday, so I don't know if you want to add to that.
Oh, why not?
Actually, yeah. Okay.
Next Thursday then, Ms. Adams?
Yes, that would be May
June 26th. Oh, May, I'm sorry. May 22nd,
I was looking at the 29th.
28th? What
The
day?
20 So the 22nd is pretty bad and you have drug court. So I was looking at May 29th. Or do
Okay,
we not want it out?
we'll adjourn this out to May 29 at 8:15 in the morning. And Ms. Moliterno will come over and meet with you. And then we'll see you back on that day, all right?
Judge, can I speak with her first for a few minutes?
Talk to who, Ms. Straub?
Yeah.
Okay, Ms. Straub, I'm gonna open up a breakout room. Do you want to join the breakout room, Ms. Moliterno?
No, Your Honor, I do not think that I need to. But I
All
can
right.
be downstairs.
Okay, all right, so Ms. Walsh and Josie 1.
You already finished with Ms. Stroud completely for today, correct?
Yeah.
Thank you.
All right, Ms. Walsh, there you go. Go ahead and join that breakout room.
Thank you.
I have Mr. Wyrick. Mr. Murphy.
Morning, Your Honor.
Good morning. How are you today?
Good, yourself?
I am good. So what one did we say, Mr. Hurton, we were gonna do from Mr.?
His name is Kelly Moe.
Oh, we are ready for Kelly Moe.
All right, sounds good. I'll get him in.
All right, thank you.
If I have a room, I'm not sure that I got an available room.
Right, I have a female gonna be leaving in a minute, so, all right,
Okay.
thank you.
Okay, yep, bye.
Bye. All right, so in the matter of the people of the state of Michigan versus Justin Wyrick, file number 24-22066FH. I'm Matthew Murphy appearing on behalf of Mr. Wyrick. Since the time set for sentencing, Mr. Murphy, you received a copy of the pre-sentence report. Have you had an opportunity to speak to your client?
I spoke to him yesterday, Your Honor. Mr. Wyrick, did you speak to me any further before we proceed?
No, sir.
Okay, Mr. Murphy, Mr. Wyrick, so you've had a chance to speak with Mr. Murphy. Are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, ma'am.
Do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, ma'am.
No, Your Honor.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? Mr. Murphy?
No, Your Honor.
All right, before the court passes sentence, is there anything you'd like to say on behalf of your client?
Your Honor, I think that the recommendation in the pre-sentence investigation report is appropriate in this matter. I don't really want to, take up any more of the court's time. I think fines and costs appropriate. When you look at the situation, Mr. Wyrick is made a lot of changes in his life, and he's going to make good on paying what he owes in this case as well, and then move along with his life.
All right, and Mr. Murphy, did you receive a copy of the victim impact statement?
I did, Your Honor.
Is the victim here today? No, okay. The victim was asking for restitution, both for lost work hours and for replacement of a purse that was stolen. What is your position on that?
Your Honor, in regards to the $40 out of the purse, Mr. Wyrick did plead no contest to possessing a credit card that was in there. He didn't plead guilty or no contest to anything involving taking that wallet. But I think in regards to the $40, he may be willing to just, pay that. But I would object to that ultimately. Like I said, Mr. Wyrick wants to make good on what he needs to. So I would object to that. But Mr. Wyrick, I think, would just pay that if the court wanted to order that. In regards to the lost wages, I don't think that the restitution should cover that. I don't think that that's, I quite frankly, I don't think that the Victims' Rights Act allows for the restitution in that matter. So I'd object to that as well, Your Honor.
Okay, Mr. Wyrick, is there anything you'd like to say on your own behalf before the court passes sentence?
No, ma'am.
All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criterion reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and protection of society. This is a misdemeanor case, obviously. So let me get that up. So pled to a larceny, to 1,000. All right, so there is a $250 fine. There is $50 in state costs. There is $75 crime victim rights fee and $40 in restitution for the purse. As correctly stated by Mr. Murphy, I can't assess restitution for lost wages due to the nature of this. So, Mr. Wyrick, what I will say is, I'm glad to see that you have at least a year of sobriety. I'm glad that you have changed this path you were on, because obviously you were heading towards, much more serious issues. So, can you pay that? It's going to be $375 plus 40. Can you pay that in 90 days?
Yes,
Are you
ma'am.
working?
Yes,
All right,
ma'am.
I'll give you 90 days to pay it. Your court paperwork will have the phone number for the clerk's office. You can just call that and they'll give you instructions on how to pay that from where you live now. All right?
One quick question. I'm actually coming into town for a graduation this weekend. The court system there has an old bond check, I guess, from a different case that I finished and everything. Can I just come in and pay it when I pick that check up?
Of course, we're open
Okay.
8 to 4:30, Monday through Friday.
Okay.
And also, we're gonna mail to you your notice of right to appellate review. I don't want your whole address, but is your house number 1137?
Yes, ma'am.
All right, so you're gonna receive an envelope from me, and in that will be 3 copies of your notice of right to appellate review. The top copy will be flagged for you to initial and date. There'll also be a self-addressed stamped envelope. So initial, date it, fold it up, put it back in the envelope, pop it in the mailbox back to me. And then the other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Yes, ma'am.
All right. Thank you, Mr. Wyrick.
Thank you, ma'am.
Thank you, Mr. Wire. Contact me if you have any
Morning,
questions,
Council.
okay?
All right. Thank you, Mr. Murphy.
All right, Mr. All right, in yellow, are you Mr. Mo?
Yes, I am, ma'am.
All right, Mr. Muwad,
Yes, Judge.
all right, I got Mr. Mo. So this is in the matter of the people of the state of Michigan versus Kelly Dwayne Mo. We have 2 files, 24-21931FH and 24-22090FH. I have Douglas Hartung appearing on behalf of the people, and I have Elias Mawad appearing on behalf of the defendant. This is the date and time set for sentencing in this matter. Mr. Mawad, do you need an opportunity to speak with your client?
Mr. Mo and I talked about the plea agreement, what it meant. He also knows there's a cap of 12 months. I think Kelly, how long you been in there right now for? If you don't mind me asking, Judge, how long you been in there?
He's got 286 days on 3-1 and 140 on 9-0.
Okay, all right. So he knows he's been in there. He's going to get credit for that, and then I can allocute. So we're ready to go, Judge. I think he's been in there a long time, and he's really dried out to a certain extent. So.
Okay. All right. And Mr. Hartung, you received a copy of the PSI?
Yes, Your Honor.
All right. So, Mr. Mo, you've had an opportunity to read and review the pre-sentence report. Is that correct?
No, ma'am.
Okay.
We talked about it. Kelly, we talked about it.
Did your attorney
remember?
go through it with you on the phone?
Yeah.
Do you need an opportunity to read it?
No, ma'am.
Are you sure? Okay. Are you satisfied with Mr. Mawad as your attorney and the advice that he has given you?
Yes, ma'am.
All right. Mr. Hartung, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Mr. Mawad, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor. Very thorough report on Mr. Mo. Thank you.
Okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect, Mr. Mawad?
None, Your Honor.
On file number 24-21931FH on the breaking and entering a building with intent count, probation department computed the minimum sentencing guidelines to be 19 to 38 months. On file number 24-22090FH on the larceny in a building charge, they computed the minimum sentencing guidelines to be 5 to 23 months. Mr. Hartung, do you agree with that calculation of guidelines?
Yes, Your Honor.
Mr. Mawad, do you agree with that calculation of guidelines?
I do.
All right, Mr. Hartung, is there anything you'd like to say on behalf of the people before the court passes sentence?
Your Honor, the recommendation from the probation department is prison on both of these charges, so we understand how serious the situation it is. The sentencing agreement capped him at 1 year. So what I'm asking the court to do on the file that ends in 3-1 is to give him 12 months in jail on that file. And on file 9-0 to give him 8 months in jail on that file. And the reason I'm staggering that is because the second case came about later And Mr. Moe and his co-defendants cooperated in that matter and agreed to participate in confessions and admissions. And through their attorney, they worked out to settle all of these cases up at one time. I'm also asking the court to put him on probation for 3 years and to have him follow any drug rehabilitation treatment programs or guidelines or testing that is recommended by his probation agent. And if there is a restitution claim put in at some point in time on both these cases, that the court order him to pay that restitution, and obviously you could have a hearing if you needed.
Okay. All right, Mr. Mawad, is there anything you'd like to say on behalf of your client?
Yeah, Kelly will tell you that when he got arrested on these charges, he clearly has an addiction, will always have an addiction, and understands he's been in so long now, Judge, that Kelly looks better, talks better, is better. He's got a sister that calls me periodically to check in on him, and they want nothing but help for him. I am happy that not just Mr. Moe and the other two, we'll talk about them in a minute, were able to talk to the detective on the second case, close it out because they gave confessions, they talked about it, and Mr. Hartung's right about everything he said. I'm thinking a little bit differently. I'm hoping that the court may think about giving him credit for everything he's done so far. I'm the probationary terms, but he's got to be supervised because we don't want him to end up dead. And that's what I care about right now for Mr. Moe.
Okay. All right. Mr. Moe, is there anything you'd like to say on your behalf?
No, ma'am.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offenses, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Sentence of court, you'll be placed on probation for a period of 3 years. During that term of probation, you will obey and comply with all the articles of your probation. You're not to use any illegal controlled substances. You're not to consume alcohol. You are not to use medications except as prescribed. Understand that the probation department has right to search and seizure if they believe that you have items which would violate the terms of your probation. You must test as required by the probation department and submit to any substance abuse assessments or counseling. You can't use any object as a weapon. Let's see. Any other terms that might be added. And that's on both files. On file number 24-21931FH, you will be placed on probation for a period of 3 years. It will assess $750 in court costs, $130 crime victim rape fee, $68 in state costs. There's a $60 DNA fee. I don't know if you'll actually have to pay that or not. It depends on when you last had your DNA done. There's a $30 per month supervision fee, along with $60 if we need to place you on a tether. You'll serve 1 year in the Lenawee County Jail with credit for 286 days already served. On file number 24-22090FH, you'll be placed on probation for a period of 3 years, all the same terms. I will give you 140 days credit for time served. There is $130 in crime victim rape fee and $68 in state costs. Obviously, Mr. Moe, if there is a request for restitution, you have a right to have a hearing on that. And of course, the court will oblige you with that. As of right now, we don't have a restitution request.
Yeah, actually, they turned in a statement. So the amount that we figured out was the amount for each.
I don't have a statement.
It should have been with the PSI. I have it here if you need it, but it's an estimate.
I have
It should be
an electrical estimate.
Yes. So it totals over $32,000. We figured out 10,700 for each defendant, 3 of them.
All right, so there's like GLIC electrical. Was that in your packet, Mr. Mawad?
Yeah, I did see that. And Mr. Mo, this is a restitution request for $10,000 on both charges, both buildings, because of electrical cords. I don't want to object to it unless you tell me I have to, Mr.
So
Mo.
you're joint and severally responsible for that restitution. So, you know, if the other two don't pay it, you might end up paying it all and having to go back after them for it. There's a 400A feed from box F feed to box D. No idea what that means. And that's $11,740. There's a 400A feed from box F feed to box G, $7,180. And a 400A parallel feed from box G feed to busway J box, which is $13,180. So that's the estimate for repairs that they provided. So what your attorney is saying is you can dispute that, or you can agree to your, and it was 10,000 what?
10,700, and that would be the Morenci case, the 090 case.
And that would be on the 090 case from Morenci, and it would be 10,900.
10,700.
10,700 for each defendant.
Yes.
So
We have no
the only
contact
question I have,
with each other.
oh, go ahead.
Yeah.
Do we know if insurance covered any of this? We may not, but does anybody know?
I don't know, the insurance company would get it, but I haven't gotten any statement other than that was in the police report.
Okay.
Okay.
I appreciate you.
Just, well, it does matter if the insurance company covered it.
Right, so they would get it. So I haven't heard from either party.
I typically don't pay insurance companies. Mr. Hartung?
I don't have a problem with leaving this issue open if, and they want probation follow up with that letterhead, or on that letterhead to find out if it was paid by insurance or not. I have no problem.
All right, so we'll leave that open right now, Mr. Mo and Mr. Wad, and Ms. Holly will reach out and find out whether or not there was insurance coverage.
And clearly no contact between the defendants.
Okay. Mr. Mo, obviously there is also a no contact between you and the other co-defendants, okay? Is that all right?
Yes.
Oh, okay, all right. Okay, so anything else? Hold on.
So on the Larson building file, the second file, I don't believe you actually assessed, maybe you didn't intend to, an amount of time in jail.
I gave you credit for time, sir.
Thank you.
Yeah, all right, and the restitution will be on file number 24-22090FH, and again, there'll be no contact order between you and your co-defendants, and we'll leave the restitution up until we can find out if there's been any insurance payments on that, Mr. Mo. Now, Mr. Mo, we're going to send over to the jail 3 copies of your notice of right to appellate review. They're going to have you initial and date 1 copy for our records. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, Mr. Mo?
Yes, so it's time served on both of them or just on one of them?
Just on one, and I gave you a year in jail.
So I got
File number 24-21931FH, you got credit for 286 days.
So I got like 15 days left.
Yeah, that's all. You're almost out, Kelly. But Kelly, you got to do me a favor. We all love you, man, and I got to know your sister. You got to take care of the meth issue. All right?
Oh yeah, I know.
All right.
Yes.
Oh, and when you get out of jail,
First Tuesday.
the first Tuesday after you get out of jail, you need to report to the probation department on the 3rd floor between 8 and 10 a.m. All right?
So this probation here
Yes.
or probation over there in Branch County?
Here.
It's
You got to
here.
go here first. Right.
It's here, and if you live somewhere else, they got to transfer it to wherever you live. Got it?
Yep.
Okay. All right. Thank you, Mr. Mawad. Thank you, Mr. Mo.
Thank you.
Thank you.
Have a
I'm
good
going to
day.
stay on to talk about, if you want to, Wayne Scott and Maynard, if I can talk to you about that. We can do it off the record real quick or whatever you want to do.
I can do it off the record. Do you mind?
All right. So Judge,
I gotta stop my, hold on, I gotta go off live stream. Hold on. All right. Hold on, Mr. Murphy, they have not logged in yet. This is in the matter of the people of the state of Michigan versus Cody Ryan Cousineau. We have two files, 25-22104FH and 25-22151FH. I have John Glazier appearing on behalf of Mr. Cousineau. Mr. Cousineau requested to appear in person, so he is here in person. Mr. Cousineau, did you receive a copy of the pre-sentence report?
Yes, I did, Your Honor.
Step up to the microphone a little bit.
Yes, I did, Your Honor.
All right, and you've had an opportunity to read and review it?
Yes.
Did you get a chance to talk to your attorney about it?
Yes. Sir.
All right, are you satisfied with Mr. Glazier as your attorney and the advice that he has given you?
Yes, Your Honor.
All right, hold on one second. Let me open up a breakout room for Mr. Murphy and Miss Rowe. So hold on one second. All right. Go ahead, Miss Rowe and Mr. Murphy, join that breakout room. All right, Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
I'm sorry, there's a credit change because I guess this got adjourned.
Okay.
The file ending in 2104 is up to 12. And the file ending in 2151 is 97.
Thank you. All right, so Mr. Glazier, the credit has been updated on file number 25-22104. It is now 112 days. On file number 25-22151F8, it is now 97 days. All right, Mr. Glazier?
Yeah, that's correct. That's fine. Your
All
Honor.
right. Other than that, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, is there just one PSI? You said there was two files.
Yeah, if you look at the top of the PSI, it lists two file numbers.
Okay.
That just should be three files. I'm sorry.
There's a second, I'm sorry, you're right. There's a second PSI, so you should have two PSIs. One just for file number 25-22198FH and one for file number 25-22104 and 25-2151FH. So there are, you're right, two PSIs.
I only have one PSI. Are they both recommending just credit for the time he's served?
They should have been attached to each other.
Yeah, they're not.
We probably got the first one before the other one because this didn't get together until later.
I can't tell you why I don't have the other one, but I only have one, Your Honor. My question is, does the other file recommend credit for the time
So,
served?
Mr. Glazier, what I'm going to do is have Miss Adams scan and email it to you. I show it was emailed to you guys on April 22nd. I don't know if you can look it up by date. The first one was sent out March 21. The second one was April 22nd.
I tell you what, I have to do a Zoom sentencing down in district court, and then I'll come over there. That might be easier.
Okay, that'll make it easier. Okay, so we'll make a copy of this one for you. So Mr. Cousineau, what we're gonna do is send you back down to lockup. Mr. Glazier, I do know that I have an abuse neglect trial I'm finishing up later this morning and some other stuff, but we'll accommodate you. So
Right.
we're gonna send you down to lockup, and then when Mr. Glazier gets done with the district court sentence, he's gonna come down and he'll read through them both with you, all right?
Thank you.
All right, thank you, Mr. Cousineau.
All right, thank you, Your Honor.
Thank you. Okay, so Mr. Dagger Margosian, I thought was logging in, but I don't know where he went.
Who's that?
Dagger Margosian, is he logging in here?
Yeah.
I don't know. Is that the only one you have?
I have him and Wade Scott.
Yeah, Wayne Scott, we're gonna wait to see if they come in. I don't
Yeah,
see him in the
and then,
courtroom. So, yeah, you can come back.
All right.
All right, so Mr. Rowe, I do know that your attorney is in my jury room. So he should be here in just a minute.
His computer's back there, I don't
You
know.
ready? He's fine.
His computer's back there, I don't know why.
Okay, so we are back with Miss Rowe. All right, so Miss Rowe, have you had an ample time to speak with Mr. Murphy?
Yes, Your Honor.
All right, are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, I am.
All right, wait a minute.
You need to bring files.
That's fine. All right, and Mr. Murphy, you've had ample time now to speak with Ms. Rowe.
Yes, Your Honor, thank you.
All right, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report, Mr. Murphy?
No, Your Honor.
Does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Probation Department has calculated the minimum sentencing guidelines to be 0 to 9 months. Do you agree with that calculation of guidelines?
I do, Your Honor.
Before the court passes sentence, is there anything you'd like to say on behalf of Ms. Rowe?
Your Honor, I think the recommendation is appropriate. Ms. Rowe needs recovery court, and she's, quite frankly, she's excited about participating in it and changing the path that her life has been on. I would ask the court to consider a reduction in fines and costs. She is working, but obviously, as you can see, she's working at Sunoco. Her wages, she has to have a lot of obligations, and quite frankly, I would just ask the court to consider reducing her, financial obligation. She needs to, as she is right now, focus on her recovery and, repairing what relationship she's lost, or what she's, damaged in her life, and she's doing that right now. So, with that, I guess I'd ask the court to adopt the recommendation with the caveat of maybe reducing fines and costs.
All right, Ms. Rowe, anything you want to say on your own behalf?
No, Your Honor, I do want to say, so I was sentenced downstairs as well on probation, and I have 3 months to pay fines as well down there, which I did make a payment today. But with my working around my recovery court schedule and my visit schedule with the baby, I haven't been getting many hours, but I am getting 2 more days added onto my work schedule to make more to pay my fines.
So they gave you 90 days downstairs to pay that off? The fines and
3
costs?
months, yes.
Yeah.
But I can get an extension, and which I did. I paid some today and got an extension.
Well, what I'm going to say to you is that pay that off first and then worry about paying on ours later. Okay? So you don't have to worry about ours right now. Just
Okay.
pay that off so that you don't get violated on the.
Now, would that interfere with the 10% I need to pay off for my phase up?
No.
Okay,
No, you're good.
thank you.
You're welcome. All right, well, anything else you want to say? Okay. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said on the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others. Is Megan Latour part of your case?
Yes.
Oh, shoot, let me let her. All right. Miss Latour, I wasn't aware you were here for Miss Rowe. I have an abuse neglect case later this morning, so I guess I thought you were on that one. So, all right. So the criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and protection of society. So, Ms. Rowe, I'm very excited that you're in the recovery court program. You've been doing really well, and we're very proud of you.
Thank you.
And so, we just got to keep that up, and we'll be fine.
Yes.
It's sentence of the court that you'll be placed on probation for a period of 3 years. During that term of probation, you're to not commit any criminal violations, not to leave the state without consent, not to use or possess alcohol, not to use or possess illegal controlled substances or marijuana, because we receive federal funding, so you can't use marijuana in the recovery court program as well. You are to test for alcohol and drugs as required. Use prescription drugs only as prescribed. Complete any inpatient, outpatient, or treatment as recommended. complete a substance abuse assessment, which I think we already have. Truthfully report to the probation department as required. Do you have your high school diploma or GED?
No, I'm still working on that.
Okay, okay. And they help you with that too. But remember, you're in phase one. So right now we're just focusing on phase one. Those are things we focus on as you progress, okay? Notify them immediately, probation department, of any change of address or employment status, obey all court orders, not to engage in any assaultive, abusive, threatening, or intimidating behavior, not to use any object as a weapon, comply with written or verbal orders made by the field agent. Obviously, they can come into your house for probation supervision. You must submit to search of your person, property. That includes your car, your residence, your computer, your phone, without need of a warrant if they have reasonable cause to believe that you violated the terms of your probation. Report any arrest or police contact, loss of employment, or change of residence within 24 hours. Maintain employment. There is a $130 crime victim assessment fee. Court costs in the amount of $750, $60 DNA test, and $68 in state costs. Obviously, that gets paid over time. You don't have to pay that right away. You are to enter and complete the recovery court program. I'll give you credit for 3 days you already served in the Lenawee County Jail. And that's it. So you do have the right to appeal this sentence, and my bailiff's going to hand down to your notice of right to appellate review. You're going to initial and date one copy for our records, just to acknowledge you received it. Okay. The other copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form. Within 42 days, we drop it off to you. All right. Ms. Rowe, you were doing a great job. Just keep it up, all right? I'll see you next week. Thanks. Bye. The record
Thank you,
shows-
Ms. Rowe. You have a good day.
Miss Rowe.
Oh, Ms. Rowe.
Agent Teskey needs you to report to her at 8 a.m. on Tuesday, okay?
Okay.
Okay.
Well, she did tell me yesterday during recovery.
Wednesday. She told you to report on Wednesday. Yeah.
So
Oh.
Wednesday or Tuesday?
Yeah, she said they're gonna tell you to report Tuesday between 8 and 10, but you need to
From
report
Wednesday,
Wednesday. So,
Okay, you
So
know
Wednesday
more
then?
than I do.
yeah,
Okay.
Yeah.
thank you. All right, so,
Everyone have a good morning.
bye. Where did Mr. Daggermar go? No, he's coming in, I think. I just heard the door. All right, there he is. All right.
Are you on yet? I'm about to be.
So this is in the matter of, what are you here for? Okay. All right, so this is in the matter of the people of the state of Michigan versus Tony Michael Rowe. We have file number 25-22191FH, 25-22192FH, and Michael Dagger Margosian appearing on behalf of Mr. Rowe. I put you in a breakout room. I didn't ask, but I assumed you needed the breakout room. So Mr. Dagger Margosian, you had enough time to speak with Mr. Rowe.
Yes, sir.
Mr. Rowe, you've had an opportunity to read and review the pre-sentence report,
Yes, ma'am.
and you've had an opportunity to discuss that pre-sentence report with Mr. Dagger Margosian.
Yes, Your Honor.
Are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes, Your Honor.
Do you wish to explain or challenge Mr. Dagger Margosian the accuracy or relevancy of any information in the pre-sentence report?
No, thank you. Oh, Your Honor.
Does the thank you. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? Mr. Dagger Margosian.
None to my knowledge.
The probation department has calculated the guidelines on file number 25-22191FH for count one, breaking and entering a building with intent with habitual criminal fourth felony to be 0 to 34 months. Do you agree with that calculation or dispute that calculation?
No challenge at this time.
All right, on charge, count number 2, larceny in a building, they calculated the minimum sentencing guidelines to be 0 to 11 months. Do you agree with that calculation?
No challenge at this time.
On file number 25-22192FH, larceny in a building, they calculated the guidelines again to be 0 to 11 months. Do you agree with that calculation of guidelines?
No challenge at this time.
All right. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Rowe? And obviously, there was a Kilbrew agreement between the prosecutor's office and yourself for 24 months with Michigan Department of Corrections, and the court will, of course, honor that. So,
Your Honor, with that being said, it's a relatively straightforward sentence. I'm not trying to minimize the conduct, obviously, but with the agreement that we reached with the prosecutor's office, I would just ask the court to follow the recommendation and the agreement throughout the process. I've spoken with Mr. Rowe, and he recognizes that he did wrong and that he has to pay for it and he has to make amends for it. But I think more importantly, moving forward, he recognizes that this is not the lifestyle and the conduct that he wants to be involved in. And so I trust and hope that when he is released from MDOC by way of parole, he will do better and be a better person. He wants that more than anything. So again, I would just ask the court to, follow the agreement. I think the items were all recovered, so there should not be any sort of restitution. And if I know the court does have to issue a mandatory minimum fines and costs. So other than that, it's fairly straightforward. I ask the court to follow.
Mr. Rowe, is there anything you'd like to say on your own behalf?
Yeah, I want to, apologize and take responsibilities for my actions and know that, I was wrong, and apologize to the people that it happened to and to everybody that's been involved in this situation with me. I just want to thank you and apologize.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record in this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to their commission, deterrence against repetition by you and by others, potential for reformation, vindication of law, and protection of society. So, Mr. Rowe, I do remember at some point in your last 17 years representing you on a criminal offense. And, again, you're always very polite. You always apologize. But I don't think that you give yourself grace to make changes, and you really have to. You were here, I think, at 17 on an MDOP, and it's just escalated and escalated to the point where you have prior felonies, 9 prior misdemeanors, and you're 37 now. You're not a kid. So you don't get, at some point you gotta stop doing stupid stuff and hurting people. And you're hurting the people that are here to support you, the people you victimized. Eventually people are not gonna be here. There's somebody here, I think you're supporting them, right? Or the victim.
In attendance, not
Oh.
necessarily.
So, it's some point people stop showing up for you, and we don't, I don't think anybody wants that. So I wish you the best of luck, but I'm hoping that you think long and hard about the changes you need to make in your life. So it's sent to the court that on file number 25-22191FH, on count 1, breaking and entering a building with intent, which had a habitual criminal fourth felony attached to it. You will serve a period of 24 months to 10 years with the Michigan Department of Corrections. I'll give you credit for 75 days served. There is a $130 crime victim assessment fee and $136 in state costs. And that is, well, $68 in state costs on that count. As for count 2 on that file, larceny in a building, since the court, you'll serve 11 months to 4 years. With credit for 75 days served and $68 in state costs. File number 25-22192 FH, sentence the court will serve 11 months to 4 years with the Michigan Department of Corrections. I'll give you credit for 75 days. Both files will run concurrent to each other along with the counts, and you will pay $68 in state costs on that file. Again, Mr. Rowe, I wish you the best of luck. I hope that you figure this out. And you do have the right to appeal this sentence, so we are going to send over to the jail on each file 3 copies of your notice of right to appellate review. We're going to have you initial and date 1 copy for each file for our records to acknowledge you received it. The other copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, Mr. Rowe?
Yes, ma'am.
I wish you the best of luck. Anything else?
The 3 sentences are all concurrent.
I did say that, yep.
I thought you said both. But all 3 of them.
All 3, yeah.
Thank you.
I said both counts with each other in both files. Yep. Anything else?
No, thank you.
All right, good luck to you, Mr. Rowe.
Thank you.
I think that's all except for possibly.
So
Miss
Mr.
Maynard.
Mawad is back, so I'm assuming he's gonna get Miss Maynard and Mr. Wainscott in. John Glazier has Cody Cruz now. I don't know what time he's gonna show back up. He's gotta go to district court. And I believe until those things happen, we're okay. But as I said, Mr. Mawad is here. So.
Judge,
All
I was not, I've been calling and calling. My guess is they're sleeping and sleeping. I will continue to call them, but I understand the fact that there's these violations, and I understand that there's possibly a new case for Ms. Maynard that if they don't appear soon, you guys can go pick them up. I'm going to continue to call them and see what I can do to get them in there today, no matter what, if that's okay with the court.
So,
Okay.
Mr. Mawad, I appreciate that you're gonna call and just know if they don't respond at some point, I'm gonna issue a bench warrant, right? So,
Very, very fair. No, more than fair. I did not know about these other matters, so very fair.
all right, so let us know when you hear from them. Thank you, Mr.
All right.
Mawad.
Thank you, everybody. Thank you.
Thank you. Okay, so.
That was good,
I
Judge.
think- All right, I'll let you know when when we come back on Mr. Glazier's file. Is that yours?
No, it's not. But I
Then I
have you at
won't let you.
1:30 for Mr.
Yeah, we got
or
something at 1:30. Yep. All
Edmonds.
right, thank you.
Thank you. But if you need me for anything else, of course, you could contact
I
me.
will.
Good morning. The 14B District Court is now in session. My name is Elaine Washington. And
I find everyone's pain funny but my own. I'm finished.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anais Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anais Battle, appearance especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battles. Direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Miss Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
Well, whatever you're using as your basis is still not correct. It is not the law.
It is. It's still under
Not
MCL and it's under the Landlord-Tenant Act.
overruled.
My objection is overruled, Your Honor?
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was rescinded?
That's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated.
My ruling, I'm not arguing with you anymore about it.
Right. It's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to asking these questions. I will continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there a proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look at. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
Yeah.
Yeah, have you read that statute?
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody, please stop typing. It says a demand for possession or payment shall be in writing, addressed to the person in possession, and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there a proof of service of it on the record?
That's a different question, though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate your objection. I just said MCL because they're both under MCLs. Both proof of service and certificate of service are both under MCL.
No.
All right, well, everybody. So let's not make my ruling.
Let's just. Okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service.
Okay.
Is not on the disposition, and just like she read on 657-16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD. Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
Object to what? I didn't say anything yet.
Well, I'm objecting because she asked Ms. Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next question.
And she said yes.
Right, and then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth
Everybody,
before you
please
objected
just
me.
let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because
This.
it's not, that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just read-
I said either federally funded or get federal funds, which you do if you accept Section 8 and vouchers.
No, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you receive any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are. Do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a
Ms.
federal
Battle.
registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that
not a
these are
debate.
the
None.
requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing here.
Ms. Battle, move on.
Move on to, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If I cannot have, this is not a fair hearing. And again, this is why
you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not, and I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
please move
all
on.
this is not right. And attorney
I'm going to
grievances.
be filing criminal proceedings against you for all these frivolous things that you're filing against me. So
If you
please
feel that
move
it's
on.
frivolous, that's fine, but it's not. My
Well,
rights
what
and
the
my
Attorney
rights are
General
not
said.
frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, Nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
cross-examination.
Battle, if
that
you're
would
not
constitute
gonna
as the
ask
same
appropriate
type of
questions, then I'm
fault.
just gonna silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't
Well,
have a real opportunity to ask the questions. So at this point, like I said, I'm just gonna have to get the federal court involved and get the marshals because I don't know what you all are gonna do. You all have not been acting in honor and with good faith. So I don't know.
I don't know
I'm
what's wrong
stuck
with
on what to
you.
do. The integrity of the
Clearly
court is
something
questioned.
wrong with you. I don't know what that is, but you should seek some mental health. Because something's
sorry?
wrong with you. You have
You
a
said
mental
what?
problem. You have a mental problem.
I
If
have
you
a
think
mental
the
problem.
laws in
How?
the United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. No, be specific because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right. I have
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action. And I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with it right after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law. That's what you're saying, right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is. It's
all right.
backed in case law, and y'all keep you.
Ma'am.
It's okay, because he can talk, but I can't talk.
Ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so
okay.
what I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present defenses that are real, and she has refused to do that.
I didn't refuse to present defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the last piece.
Your rescission is not a defense.
Okay, that's fine.
It is your defense.
Right, because, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the subject
We're
matter.
going down the same road.
Okay, listen, stop. I didn't cut you off. I didn't cut y'all off. You just asked me what my defense was. And
all right, I'm done.
Wow. You're asking me what my defense is. I can't.
Take her out. I've asked her 3 times to stop this. All right, I'm going to grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes.
Thank you.
Thank you.
I'm sorry.
Thank you, Judge Washington.
I'm sorry you had to go through that.
All right, thank you.
Thanks.
Appreciate it. Bye.
Bye.
is State of Kansas versus Leslie Aaron Hudson. It's case number 2023 CR 18. James Watts appears as defense counsel, Ms. Hudson on her own Zoom, Amber Norris on behalf of the state. Ms. Hudson, it's generally the policy of the court to require all persons on this docket to be actually appearing at the Judicial Center in El Dorado. You weren't told at your first appearance on this that you needed to be at the Judicial Center?
No, sir.
The original sentence in this case was for a conviction of possession of methamphetamine, a level 5 drug felony, with the defendant receiving a 13-month DOC sentence, 18 months community corrections probation. We have had a prior warrant to show cause hearing. It does appear. The docket notes from March 14 indicate that the court at that time ordered a 3-day sanction, ordered the defendant specifically to complete treatment. And now I have before me a new warrant to show cause, which alleges a number of ostensibly new violations. The defendant apparently was arrested in the state of Oklahoma and did not notify the officer of that law enforcement contact or arrest. The defendant was in, according to the Oklahoma probable cause affidavit, the defendant was in Newkirk, Oklahoma, and she didn't have permission to be in Oklahoma, and that the defendant at that time was in possession of methamphetamine, fentanyl, and marijuana. Also, the allegations are that she never got back into Senate Bill 123, intensive outpatient treatment, after being reinstated on probation back in March. And that the time of her arrest was outside of her 11 o'clock p.m. curfew. Those are the current allegations before the court. This time, Mr. Watts, what announcement is made?
Your Honor, as to the allegations, she would acknowledge that on March 26, she was taken into custody in Oklahoma. She did not notify her probation officer of that at the earliest possible date. She would likewise stipulate that she was in Oklahoma, obviously, on that date, and was not in area she had a travel permit to be. She obviously will not stipulate she was in possession of anything at that time. I would note that at the time of this warrant to show cause filing on April 8, she was not back in Senate Bill 123 treatment. I am told by my client that she is now back in that treatment program, but she wasn't at that time. And she will likewise stipulate, and finally, that it was 1:15 in the morning, past the 11 o'clock curfew at the time of her arrest in Oklahoma.
All right. Ms. Hudson?
Yes, sir.
All right. Based on the announcements of your attorney, it's the court's understanding that you now wish to waive your due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence, confront their witnesses unless good cause was shown, present your own evidence at such a hearing. And I'll also inform you that among other lesser remedies, the court could, finding a violation of the terms and conditions of your community corrections probation, do an outright revocation of your probation and order you to serve the remaining balance of your sentence locked up in prison. Do you understand these things?
Yes.
Okay. So do you now waive a hearing in this case and stipulate and agree that you committed the violations of not reporting your Oklahoma law enforcement contact, being without a travel permit in the state of Oklahoma, not being in treatment at the time this affidavit was filed, and essentially being out after your curfew? Ms.
Yes,
Hudson?
I didn't think about that at the time.
Right.
I was just trying to go in there to help my dad and I wasn't thinking about anything else.
All right. The court does note the defense's reservations about admitting the drug possession, which is alleged in the affidavit. Is the state still pursuing that allegation?
No, Your Honor.
Very well. Court finds that the defendant has waived her right to a hearing as to the other allegations, stipulates and agrees that she committed the violations as alleged in those other four. Court finds that these are substantial and material violations of the terms and conditions of probation in this case. Ms. Hudson, where are you at currently?
I'm in Winfield, my dad.
Okay, you previously on your bond had listed an address in El Dorado. How come you're not there?
And I didn't know I was supposed to be there on Zoom. He was fixing my truck and I stayed the night with him.
Okay, I'm sorry, I didn't hear that last sentence. Would you repeat that, please?
He was fixing my truck and I stayed the night with him, so I just went ahead and did my Zoom over here.
Okay. I trust that you have a ride that you can get here.
Yes.
Okay, well, I want you to head this way. And I want you to come to the Butler County Judicial Center in El Dorado before the court announces its disposition. So my calculation is that you should be here in an hour. So if you get in the truck right now and head this way, we should be able to take up your case at about 4:45. Ms. Hudson, I don't think I need to tell you what the court's view is going to be if you don't show up when the court tells you to. You should have been here for the start of this hearing. If you weren't told that by the first appearance judge, you should have been. I'm not comfortable about proceeding to disposition on this case until you are available here in this locality. Okay?
Yes, sir.
So I'm going to recess this proceeding and we're going to take up your case probably about as soon as court security reports to my office that you are in the building and that you're ready to participate. Okay?
Okay.
Anything else about
Okay.
that, Ms. Hudson?
No, sir.
Okay. Okay. All right. I can go ahead and release you from the Zoom meeting at this time. You need to get in your vehicle and get to the Butler County Judicial Center in El Dorado, Kansas as soon as you can.
Okay.
All right.
Yes, sir.
We'll move on to another matter on the docket at this time. All right. Mr. Watts, I think you have one other case on this docket. Alex Curry.
Judge, I do. Alex Curry. I've also just got a message from Joe asking me to assist him. He's stuck in another hearing for a, hang on a second, a Belleville.
Yes.
Okay. Is this
So
Mr.
he is not going to appear on this docket to represent Mr. Belleville?
It sounds like he is stuck in another hearing with a translator and it's taking a great deal of time. It sounds like Mr. Belleville, he tells me he is going to waive and the dip will be recommended. Is
Okay,
this
in
Mr.
fairness to
Belleville?
him, you probably need to confer with him privately, Mr. Watts.
Okay. Is this Mr. Belleville here?
No, I think that's Mr. Curry, isn't it?
Is this Mr. Curry?
Yes.
Okay. Well, as to Mr. Curry, I have in front of me a request for pro se request for a sentence modification as well as a not sure what else, dispositional detainer.
Yeah, I wrote those while I was in another county, so
Okay.
the dispositional detainer doesn't.
Okay.
But I just wanted to. I didn't know if I was eligible for a sentence modification or not.
Well, Your Honor, I'll need to speak with Mr. Curry. Sounds like he was in another county until recently.
All right. Let's go ahead and put Mr. Watts and Mr. Curry in a breakout session at this point and allow those two to confer. Time the court will call the case of State of Kansas versus Alex Michael Curry. It's case number 2022 CR 210. Alex Curry appears from the Butler County Detention Center Zoom location. James Watts appears as defense counsel. Amber Norris appears on behalf of the state. This is a warrant to show cause matter alleging probation violation. Worth noting that a proceeding was held on probation violation on September 29 of 2023. The defendant was then released back onto community corrections with probation extended to December of 2024. All right, if you could clear something up for the court, Ms. Stanfill, I note that the arrest warrant to show cause appears to have been filed with the clerk's office on February the 7th. Your signing date was February 6th of 2025.
Same thing.
Looks like it was sealed on February 6th, Your Honor. Per the clerk.
Is your request for court review of this case timely, Ms. Stanfill?
Yes, I filed a journal entry of modification when he was being supervised by Cali County, and it was filed on December 6th, 2024. I extended it for 1 year.
Very well. We'll proceed further. Mr. Watts, it is your client's intention to stipulate and agree that he committed the violations alleged?
That is my understanding, Your Honor.
All right, Mr. Curry, that would means that you would be stipulating and agreeing to failing to report as directed, not working at suitable employment, apparently had positive tests for THC, amphetamine, and methamphetamine, positive for alcohol on another occasion, and not being engaged in outpatient treatment. Ms. Curry, do you understand that you do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence? You can challenge the state's evidence with the assistance of your lawyer, present your own evidence, confront the state's witnesses unless good cause was shown. And I need to point out to you that among other lesser remedies, the court could consider outright revocation of your probation and having you serve the remaining balance of your sentence locked up in prison. Do you understand that?
Yes, I do.
And that your controlling sentence in this case is 10 months Department of Corrections custody. Do you understand that?
Yes, I do, Your Honor.
So do you waive a formal hearing in this case and stipulate and agree that you committed these violations?
Yes, Your Honor.
All right. The court finds that Mr. Curry knowingly waives the hearing and stipulates and agrees that he committed the violations alleged in the warrant to show cause and outlined here on the record by the court. We'll now proceed to disposition in the case. I'll ask for recommendations from various persons, beginning with Amber Norris on behalf of the state of Kansas.
Your Honor, as previously noted, this is defendant's second warrant to show cause. He'd previously been before the court and has had one dip that was in 2023. And as noted by Ms. Stanfill, she has done a modification to extend his probation, which, and the reason stated in the modification is additional time to successfully complete alcohol and drug treatment and to pay restitution in full. Your Honor, it's my understanding that the defendant has been in custody for some time. Most of that time he has been in Reno County. I think answering for a warrant to show cause there. And then obviously he came back to Butler in April. He has earned on this warrant 30 days of jail time credit. He came to our jail on April 17th and today is May 16th. So he does have 30 days in the county jail. The court previously gave him a dip. Your Honor, it's my understanding that he's been accepted into, I think he's got something set up for inpatient. He's been accepted into, I think Reno County has a drug court program. And I think he's set up to maybe move into some sort of an Oxford house. The treatment bed is in Pittsburgh and for inpatient treatment, and it's to begin on May 22nd. Your Honor, we might make suggestion that the court hold him until closer to that date. I think it's my understanding that transportation, I think, is already arranged through maybe Reno County. But Your Honor, ask the court give defendant an appropriate sanction. Like I said, he's already been in for 30 days. It doesn't sound like he would need an extension of probation since he's already extended to December of 2025. I don't really know defendant's history on whether or not, I mean, he has had opportunity for treatment in this case, and has not ever completed it from what I understand. And obviously he's been on supervision in this case for a while now, as just based on the year of the case, 22 CR 210. But Your Honor, I do believe that a little bit of additional sanction besides the 30 days, and that he be ordered to complete all the previously ordered probation conditions, which includes treatment, which he has yet to finish up, and the court will need to address additional court-appointed attorney's fees and the bids application fee.
Very well, Ms. Norris. Mr. Watts, your recommendations regarding an appropriate disposition here?
Ron, I'll be very brief. We join the recommendation of the state of the DIP, place him back on probation and complete this program.
I think Ms. Norris had actually suggested to this court that we hold your client until his treatment bed opens up. Now, first of all, the court has some reservations about whether Mr. Curry should even qualify for an inpatient bed. He's been locked up apparently for weeks. I would think any detox that would be connected with inpatient treatment has already been satisfied by his extended jail stints. But with that said, are you contemplating a recommendation consistent with Ms. Norris that we hold him until May 22nd, when apparently he's eligible for transport to an inpatient facility?
Judge, I'm supposed to speak for my client here. I'd like to get out today, I'm sure, but a hold till May 22nd, which at this point is about 6 days away, seems to be appropriate here.
All right, so noted. Ms. Stanfield, you've listened to what's been suggested to the court here. Is there anything that you would like to add?
No, the only thing, just to let you know, his mother was going to make arrangements. If he just got a 3-day dip, his mother was going to make arrangements with Second Chance Sober Living for him to stay there until Reno County picked him up on the 22nd. And she was going to bring him clothes for inpatient. But if you decide to keep him there, mother can always take clothes to the jail for him to go into inpatient.
All right, thank you. All right, Mr. Curry, at this time, the court will address you personally and ask you if you have any statements that you wish to make in mitigation of punishment here.
Your Honor, I just want to let, I remember when I got sentenced by you a while back, and one of the things you wanted me to do was to obtain my high school diploma and my GED. While I was in here, I applied to get into the Orion program, and I talked to Mr. Friesen, and he's got me a paper right here. It's set up for Reno County at ESDAC, and they're currently closed right now, but the school, he said I can enroll in August to try to get my high school diploma. So, because that's something that I want to do. And I've been working on while I was in here.
Okay. It's good to hear. Anything else, Mr. Curry?
No, Your Honor.
Mr. Curry, I originally sentenced you apparently in December of 2022. Your probation should have been completed by now. This court has little optimism that you're really motivated to successfully complete probation in this case. I find myself wondering if really we just shouldn't have you do your time, which might have the net result of you getting revoked also in Reno County. You could be looking at a considerable amount of prison time here, Mr. Curry. I mean, it's not like you haven't had explained to you in uncertain terms what you needed to do to successfully complete your probation, and you don't seem to do any of it. You don't report, you don't, since your probation is treatment focused, you haven't completed or taken treatment seriously. It's only when you're on the brink of prison do I see that you're apparently dedicated to making progress on your case, and it's awfully late in the game for that. Wouldn't you agree, Mr. Curry? Do you have a response for me?
I don't think it's too late, Your Honor. I'm pretty motivated right now, and I don't think it's ever too late. You know, I mean, I don't want to do this no more. You know, I
Okay.
really don't.
Well, I kind of listened to your comment. It's never too late. Well, actually, it is for some people because it gets too late for them. They end up doing their prison time. Now, as far as after they get out of prison, can they still work on substance abuse issues after they do their prison stint? Yeah, some people do that. And you're dangerously close to that, Mr. Curry. But here's the way the court sees it at this point, Mr. Curry. Should your community corrections officer recommend to this court that we just declare this a defeat, and I could certainly see grounds for that, that's probably what the court would do. Just find this to be one of those unsuccessful probation cases and have you do your time, because you certainly haven't done much to show that probation was the right alternative for you. But it does appear that there are some things in place now that give you one last chance, Mr. Curry. And maybe, just maybe, you're ready to take advantage of that one last chance. In other words, having treatment set up and a plan for where you're going to stay, when you're going to do it. I think the court wants to give you that one last chance, Mr. Curry. So I'm going to follow the recommendations in this case. I'm going to order you, though, to stay in custody until May 22nd. Who would be transporting you to the facility, Mr. Curry?
Reno County.
Okay. Well, I presume Reno County will know that you're going to be picked up at the Butler County Jail on that date, and that your mother apparently can bring you clothes there to the jail so that you can then be transported by Reno County to the treatment facility. The court will require you to complete the treatment originally ordered, complete any other satisfied, unsatisfied condition of your original probation or any subsequent order. The court's expectations is that you not only complete a treatment program, Alex, but you also complete any aftercare recommendations which are made. You're going to need some reinforcement for a while, and I think you would even agree with that.
Yes, Your Honor.
So you're going to need to successfully that portion of your program as well. All additional bids assessments would be waived in this case. He's been in jail. He doesn't have the financial resources to pay more. Anything that's still unpaid from his previous orders remains to be collected in the case. All is immediately due, payable, and collectible. We're just not going to add any more to it. I do note that pursuant to the extension order referred to by Ms. Stanfield, it appears that Mr. Curry will be on probation in this case, I think, to December of 2025, Teresa?
Yes, Your Honor.
Well, I don't see the need for an extension at this point because, Alex, you're going to have everything all done by then, right?
Yes.
Okay, that's the right answer. That's the right answer. And I just hope that you have the motivation this time to do it because you, like I said, this is your last chance. Okay?
Thank you, Your Honor.
Good luck. Alex, I'd rather just see you complete the treatment that you obviously need, stay out of trouble, follow your other probation conditions, work with Teresa or any other community corrections officer, and still be a successful completion of this case.
Thank you.
Can do it. I think you can do it. All right. Ms. Norris, is there any other specific order that the court needs to make at this time?
No, Your Honor, thank you.
Okay, so he's going to do from now until May 22nd as a sanction, then be reinstated on community corrections at that time in this case. Mr. Watts, anything further we need to address here?
No, Your Honor, thank you.
Ms. Stanfield, do you need any further clarification from the court?
Well, I don't need clarification, but I do want to make sure the jail, he is supposed to check into inpatient in Pittsburgh, Kansas at 10 a.m. So if he's ready and able to leave the jail by 7:30 or 8 a.m., Reno County should be there at that time to pick him up.
Okay.
We can schedule that.
Okay, thank you. We appreciate that. We want Alex to get there on time and get off to a good start.
Thank you, Your Honor.
All right. Good luck, Mr. Curry.
Thank you.
Nothing further. The Alex Curry matter will be in recess at this time. Court at this time will recall State of Kansas versus Leslie Aaron Hudson. It's case number 2023 CR 18. Mr. Watts and Ms. Norris appearing as before. However, the court will note that Leslie Hudson had appeared by remote Zoom today as part of this probation review docket. She did waive her hearing in this case and stipulated and agreed that she committed a number of violations in this case. The court postponed disposition until Ms. Hudson could appear at the Butler County Judicial Center in El Dorado, Kansas. Ms. Hudson represented to the court that at the time of the Zoom portion of this hearing, she was located in Winfield, Kansas, and did apparently have some means of transportation available to her. Court had ordered her to immediately head this way and get to the Judicial Center so that we could complete her hearing. In the view of the court, it should not have taken her more than an hour to get here. It's been more like an hour and a half. It appears to the court that Ms. Hudson is not going to appear and face her disposition while in the local area of the Butler County Judicial Center. Therefore, at this time, the court will find that in regards to the court's order made earlier, that this defendant has denied it. She's defied it. And therefore, the court will order bond forfeiture and a bench warrant issue for Leslie Hudson arrest, with her to be held on a no bond hold until her probation hearing can be completed by this court.
Your Honor, I should note, I heard from Ms. Hudson approximately 20 minutes ago, just before 4 o'clock. I'll be perfectly blunt. I kind of gave her the sharp end of the stick at that point. She had at that point not yet left Winfield because she was waiting on her father to come back from the store.
Waiting on her father to come back from the store.
That's as she put it. Yes, Your Honor. And that was her transportation. I kind of had the same reaction you did. You should have been here by now.
Well,
Your
Counsel,
Honor.
I can't hold all these people indefinitely. I'm just going to order that if she shows up, she's taken into custody pursuant to the court's order, and we'll go from there.
Yeah, I'll make out a jail card if she shows up in the meantime, saying that you issued that no bond hold, so that way the jail will take her until they can get the proper warrant sent to them.
Thank you. I do appreciate your assistance and cooperation in that regard. Thank you all for your patience here this afternoon in waiting for her to show up. And at this time, I'm going to order that this meeting be ended for all at this juncture.